where a judge has passed an order that he files it within 30 days? I mean, I don't understand what kind of objection there is.
I didn't
Let's
say
go
that.
into the merits of the
It
matter.
was the court who put this
I'm
question.
just saying.
He didn't say a word.
No, but even the court is not objecting. But this is what you said last time.
No, you are saying which paragraph?
Para 7.
That's a submission.
Para 7 of the order, page 61.
Submission. Let's read para 7.
No.
It's a submission.
And the apprehension is expressed.
I have some objection, preliminary.
Learned
But after retirement of Justice Oak, this is filed.
Again, I knew
This
that
is
this objection was
not
coming.
in good
Within
taste.
30 days, I am entitled to file. I filed it within
Yes,
30
but
days.
this is not in good taste.
What is not in good?
It's not filed in
May I
within
tell
30.
you? May I tell you how many matters the government of India has filed?
Mr. Sibal, address us on paragraph 7.
I'm sorry.
Address us on paragraph
That's
7.
right, Mother. That's what I
How
was
it
trying
is
to say.
prejudicial to your client. It's a submission.
I'm sorry.
It's not a finding, it's a submission.
No.
Recording of the submission.
I tell you, I'll read the what.
Please
Just the
read.
background is I get
Please
paid.
read paragraph 7.
All right, wait. An apprehension is expressed on behalf of the applicants that again the
No,
second
where are-
respondent. Para 7 and page 61.
Which
61.
Expense for bail not outside.
Oh, this is some other order.
MA 1185.
Got it, page 61, page 61. Look, the background is,
Just a minute,
Yeah.
please. Is it that K.VIDHYA Kumar versus
that's correct.
Deputy Director?
That's correct.
And the MA is MA
MA is Mother's 2454.
2024,
2454.
right?
That's correct.
Along with MA number 522 of 2025.
No.
Uh-huh.
No, that's correct.
1185, Mother's. MA 1185.
No, you want to be a minister again.
Order is
You want
in,
to be a minister.
The order is in
2454.
in the top.
Right on top, Mother's. 2454.
Are you reading annexure A6?
Correct. Page
That's
59.
correct. That is correct.
So there are two MAs. One is on the top, MA number 2454 of 24.
This is the second one, Mother's.
Then there is another MA 522 of 2025 in so and so,
That's-
recalling the court's order.
Two MAs, Mother.
So there are two MAs which are disposed of by this.
That's right.
One
So-
thing, Your Lordship, may note.
All right.
Your Lordship reads the MA.
Can we read the first paragraph so and to
Yes,
understand what
we'll
was-
read the first paragraph.
Just 1 second. Lord. So bail was granted. Lord, a review was filed. The review was dismissed. After that, this MA was filed. So bail, review, and an MA asking for the same thing.
No. Bail was granted by this court.
Yes, by this court.
When he was not a minister.
They filed a review, dismissed.
After getting bail the very next day or 2-3 days after he became
Yes.
minister.
Correct.
Then
That is
probably-
recorded by the.
Mother, 1 second. Let's hold on.
This is how,
Let's hold
He
on.
was a minister. He had resigned. And after bail, he became a minister. So review was filed, review was rejected. Then this MA was filed for the same thing.
all right,
In
now,
that MSc paragraph.
now we fairly recollect the facts.
Right.
Now we can read, please.
Now,
Yes. By way of the present, Your Lordship wants me to read the first paragraph or?
Yes.
By way of the present application, the applicants are seeking recall of a judgment and order dated 26 September, passed by this court in criminal appeal so-and-so,
Granting bail.
granting bail to the appellant, who is the second respondent in miscellaneous application so-and-so. The said criminal appeal was preferred by the second respondent against an order dated 28th February, passed by the learned single judge of the High Court. The second respondent was arrested in connection with an offence under Section 3 of the PMLA.
PMLA.
By the impugned order dated 28th February, the second bail application made by the second respondent was rejected by the learned single judge. The second bail application, this is important, Mullahs, was premised on the change in circumstances that the second respondent had ceased to be a minister in the government of Tamil Nadu from 13th February. Now, if you read that bail application, it is not premised on it. Not a word about it.
I have quoted
Will you,
that.
will you, why are you interfering, sir?
No, it's a
Will you allow-
factually.
Will you allow me? I never interfered.
Just a
Anyway,
minute.
I'll show.
Allow me to. Factually, Mullahs, not a word about it. Let's see further. By the judgment of 26 September, this court granted bail to the second respondent not on merits, but for the reasons recorded therein for preventing violation of the rights of the second respondent guaranteed under 21. The attention of this court was invited to the decision of this court in Balaji, indicating the role played by the second respondent in regard one of the predicate offences of influencing victims while he was a cabinet minister in the government of Tamil Nadu. as the second bail application
Yes.
proceeded on the footing that he is no longer a minister, this court did not consider the said decision against. Again, Malaj, there is completely wrong.
No, this is, you see, Mr. Sibal, you can't say wrong or right for the reason that this is the reflection of the mind of the
Exactly.
court. The court is saying so that.
No, but see the order, we have the order.
Yes, that's right.
The order doesn't reflect any of this.
Subsequent orders also show that.
Let him go back to jail and
Jail.
be here.
You see, this is the court is disclosing its mind that what waived with it in granting bail. The change circumstance brought before this court was that you are no longer a minister from February 24. Therefore, in September 24, the court is granting bail.
Maybe it is in the mind of the court, but it's not reflected in the
Why
order.
did he resign?
I appreciate what my lord is putting to me.
Why did he
It's not
resign?
reflected in the order.
This is also court is saying, these observations are also by court.
Well, it is kindly see, it says there is no longer, this court did not consider the said decision against the appellant.
It is considered. This decision
It
is
is
considered.
considered, Malaj. I show that to your lordship. I've got the order with me.
Yes.
Now kindly come see. Then you come, the occasion for filing these applications and for entertaining these applications by the court arose as within 2 days of this court. This court enlarged the second respondent on bail. He was sworn in. So that's what concerned the court, Malaj. Then comes to 7 straight away. An apprehension, para 4, from the
Para
date the notice was issued, repeatedly time was taken on behalf of the respondent to take instructions. That's fine.
What instructions I have said,
Again,
court
now
has
I think-
record.
I think you go ahead.
Court has record.
Go ahead, Mr. Next time you argue, I'm going to interfere at every stage.
Mr. Sibal, you are reading para 7 with you.
Very unfortunate for the solicitor to do this time and again. An apprehension is expressed on behalf of the applicants that again the second respondent will assume a position as a minister or any other position of power. In the light of the decision of this court in Balaji, and in the light of the fact that the bail application made by the second respondent was entertained only on the ground that he is no longer occupying the position of power, we do not think there is any basis. This is completely wrong.
Mr. Sibal, this is the mind of the court. The court is saying so.
But Manoj, the order doesn't say so, Manoj.
Order-
Acha, all right, assume Manoj, assume the court is saying. Let's move forward, Manoj. Manoj, what prevents a man to have a position of power while he is being investigated?
That we
Nothing
cannot
prevents.
appeal over this.
We cannot stop him from being a minister.
There can't be an injunction, Manoj.
Constitutional rights.
While the trial.
There
is
can't
on,
be an injunction, Manoj.
It's a condition of bail, otherwise.
No, there is no condition of bail.
Condition of this that he won't be a minister.
From being a
The
minister.
court has not prevented you from becoming minister.
Yeah.
Of course, we might not be in a position to prevent you from becoming minister. But the day you become minister,
Yeah.
and we find that you have been earlier indulging in influencing the.
Then you
witness-
cancel my bail.
Yes, we will recall the bail.
Yes,
order.
please do that. Please do that.
I'm sorry,
Cancel
Manoj.
my bail.
Let me make this clear. We filed this application. This order came on my application.
Again, you're.
That
It came on
today
my
itself-
application.
That today itself we recall the bail order and send you inside and.
That's
No
it.
problem, no problem.
That's what the court said. Why-
Again, sir.
Yes,
Please.
because
hold
they are
on.
factual,
Please hold
wrong
on.
statements.
I don't know why.
Mr. Sibal, problem is that we can't modify the order in peace.
I'm not asking modification, Manoj.
You are
I'm
asking-
No. All I'm saying
These are
is,
the reasoning given by the
all I'm
court.
saying is, Manoj, the fact that there can't be an injunction, a mandate, Manoj, of a court, that while you are being prosecuted, you
Mr.
can't hold a
Subal-
position of power.
Mr. Sipal, we cannot and we don't read the order as an injunction on you from becoming a minister. However, your becoming a minister, in our estimation and in light of these observations and other earlier orders, will be a relevant
Yes,
consideration
certainly.
with regard to your continuation in bail or alternatively the situs of trial.
Right, no doubt about it. There's no issue on that. But Manoj, this can't be read as which is what they are saying. This can't be read as an injunction against me for holding a position of power. If I'm influencing
The
witnesses,
overwhelming atmosphere
Manoj, if
in
there
a
is,
state is impacted by your accepting ministerial responsibilities, we have to ensure that the clear stream of justice is protected.
no doubt, but all I'm saying is if I am found indulging in any act of influencing anybody,
Already found.
there is no allegation of that
There is-
sort
there
in
is.
any state.
There is, we have made an
Manoj,
allegation.
in the bail, there is no allegation.
No. Paras 3, 4 and 5, Mr. Sibal should have read paras 3, 4 and 5. I did interrupt.
paras 3, 4 and 5 show the thinking of the court.
Simple, the allegations were there. The very opening line para 7 says apprehension is expressed on behalf of the applicant that against the
Next line is not apprehension. In the light of the fact that the bail application made by the was entertained only on the ground. That's not true.
Please see two paragraph
Not
up.
sure.
Please read paragraph 3.
Well, I will
Mr.
not-
Sibal, you have to be fair. Please read
Unless
paragraph.
I decide to read what I want to read. You can't force me to read what you want me to read.
Let the
You
court
can
read
read
para
it,
3.
you can read it. Let me show you the order of the court granting me bail on the second occasion. Yes, page 12. Yes, page 12. This is the bail order, Balaji. Not a word in this about minister. Not a word. Para 10, Balaji. Hold on. Kindly see para 10 at page 19.
Page
Page 19, para 10.
19.
19.
Yes.
Because the judgment starts at page 12. And at page 19, para 10, the learned SG relied, I'm sorry, my lord, Justice Bagchi has it. The learned SG relied upon a decision of this court in Balaji versus so-and-so. He pointed out observations made from paragraph 17 onwards of the said decision. He pointed out that this court objected strongly to not registering offences under the PC Act. He pointed out the observations of the court regarding the compromise entered into. It was observed that two teams were created just for, see, so this all is recorded. And then, Malaks, then the submissions are considered. And then para 30. The decisions that the SG relied upon indicate that the appellant's influential position in the state may have resulted in a so-called compromise between the bribe givers and bribe takers. Considering the apprehension of the appellant tampering with evidence, stringent conditions must be imposed.
No?
That's at para 30,
That
page
is-
34.
Doesn't that itself shows that your position as a minister was a relevant consideration in balancing?
And
your
granted me
liberty?
bail.
So that was a consideration.
Yes, yes.
That-
But I'm not, Manoj, and then they said that in order to ensure that I don't influence witnesses, stringent conditions will
And
be imposed.
there the MA comes into relevance that notwithstanding those conditions, there were allegations of influence.
No,
That
Manoj,
is what I
not a
mean.
single allegation of
That is
influence.
what I mean.
No, Manoj,
On
if you
merit-
read this order,
Merit bench found that prima facie the allegations were correct against you because in para 13, the prima facie finding is against you that there is some substance in the allegation.
no, Manoj, no, not on influencing witnesses,
Then
Manoj.
court went on the question of Article 21. My judgment is referred to in para 26.
Correct,
Najib
but it's
case
not
is
on influencing witnesses, Manoj. No, I'm sorry, there's no allegation of influencing witnesses.
again referred to in para.
There's no allegation of, but Manoj, let's leave it at that. There's no allegation of influencing witnesses. And I bow down to what my lord says, that if it is found at any stage, Manoj, that I am indulging in such activities that may influence the trial, Manoj, certainly your lordships will recall the order. The trial is yet to commence, Manoj. There's no question of any influencing anybody. And there's no allegation that before the trial has commenced, I've contacted anybody, nothing of the sort. I have cooperated fully.
Bail is granted only on the ground of incarceration. That's all. 21.
That's right. There was no issue of a ministership at this stage. Manoj, he was not a minister anyway. Stringent conditions were imposed. Manoj, I've been following those stringent conditions.
You see, this, the order which you are asking us now to clarify, in the name of clarification, you are actually asking modification or recall of that order.
Oh, it doesn't matter, Manoj.
Manoj.
I am only saying, Manoj, it should not be understood. This order should not be understood that there is a mandate that a person who is undergoing, Manoj, any kind of prosecution is not entitled to receive,
The order is not by the stranger bench, it is by the same bench which granted you bail.
That's correct. So,
The
Manoj,
court has disclosed its mind.
that's right. I'm not disputing that, Manoj. But the court has not said that you cannot hold a position of power.
Right, the court has not said, the court has not said.
That's, I'm only saying that, Manoj.
There are some
I'm
other
only saying
orders
that.
also I'll
It should
place.
not be understood in that fashion, which is why I'm seeking clarification. That's all. It should not be understood in
The
that
previous
fashion.
orders
Because
have to be
as a
seen.
matter of law, I'm sorry, as a matter of law, Manoj, such a mandate cannot be issued by the court.
There is no mandate, my lord. The court gave them two options. The
No,
liberty of
again,
minister.
my learned friend is completely wrong.
I'll
The
read
court-
from the order,
No,
sir.
1 second. What the court says is that you have become a minister within 2 days. You seek instructions, and whereas we sought instructions, and then he resigned.
Exactly. Therefore, Mr. Sibal, para 4 and 5 become very significant.
Yes, today a
And
copy of the
rather
press.
para 6 also.
Yes, whereas I produced that press release before the court that I have resigned. Then whereas they said that he will become a minister again. The court said, we're not going to pass any such order. We are only going to make this observation.
Court after granting
Yes, you
bail,
were there. Don't say that.
24th March 25 order, please read that order, my lord.
Yeah.
after the grant of bail, the court took very strong exception to you becoming minister.
That's correct.
Exactly,
No
exactly.
dispute. No dispute on it. No dispute. But then said you resigned. We resigned. Now what is the date of that order, Malad?
So therefore, what was the purpose? The purpose was
Just see the date of this order. April 28th, Malad, just.
Till you earned a clean acquittal, you should not hold the public.
Correct.
No,
office.
Malad.
Correct.
So get the date of this order, Malad. Could you kindly see the date of this order?
September 24,
September.
26 September 24. bail
We are,
granted.
Malad, yes, we are in.
And the court is clarifying it in April 25.
That's right, Malad. So therefore, we are from April to now onwards. I'm not a minister. I'm not a minister, Malad. It should not be. I did not become a minister, but it can't be a mandate against me. Malad, is all I'm saying.
Therefore, Mr. Sibal, at any point of time, say suppose you want to become a minister, then probably you file an application, seek permission of the court, we will consider.
No,
whether-
Malad, but that is like it's a man, then your lordship is reading it as a mandate, Malad,
No,
which my
no.
lord said you're not. My lord just
We are-
said.
Therefore, why you are asking us to come, if you are in your.
Fine, Manoj, I'm just fine. It doesn't matter. Your lordship need not pass an order because it's not a mandate, Manoj. Then well,
Better you don't press this application.
I know that, but why?
In the predicate
My lord
offense,
is not
not one
saying-
day in jail,
My
because
lord
it's
is
his
not-
state
you
government.
cannot become.
Not one day.
That's
One
one
day.
fact that's going to be taken into consideration if they file an application. With no
Lord,
problem with
Lord,
that.
before he even withdraws, my lord, would your lordship allow me to show some judicial orders passed?
In this
which are-
matter,
In this very matter. Kindly take my affidavit, my lord, on record.
see what they
Lord,
did. in
it
this
is my
court over-
specific case that this is an abuse of the process of law. Lord, kindly have, my lord, my affidavit.
Then
Lord,
it will be deemed to be a mandate. Then I'll argue on the merits, Manoj.
Kindly have a look.
No,
I'm not
no,
arguing on the merits.
There is
I'm
no merit.
arguing,
This is-
I'm just reading.
If you withdraw the application, there should be going to be a question.
Yes,
But just, I
Should be
think,
dismissed with cost, my lord. I'm
Why-
sa-
why should-
saying it with sincerity.
see what happened on
seriousness
day
in
after
mind.
day after day before this court. Eventually, the court had to pass the order of 24th March 25 before this.
Page
Please read that
75,
order.
page
The
75.
lordship will see the mind of the court. 24th March 25 order extracts step by
I
step by
reply
step
page
the
75.
long rope that was given to
I
him.
concede the fact.
From this order
My
also.
lord, page
Yes,
75 for
concede
my
the fact that
satisfaction.
the court was
Please read
upset.
page
Well, I
75,
accept.
order of the court.
The
Page
court-
75 of the
I
Aegis counter.
accept the fact that the court was upset that within 2 days I become a minister.
No, no,
I
no.
accept
It's not just
fact.
that. It's not just that.
Yes, I was there.
Very
It's just-
Counter of
Please
ED,
read the order, my lord, rather than, my lord.
counter of
What
ED,
order?
page 75.
Lord, it is
What
Arvind
order?
Kumar Sharma, my lord, advocate for the respondent,
What
just
is
for
it?
identification.
What is
He is the government AOR.
What is this order? Whose order is it?
In MA 1185, I have filed my reply.
Formal notice about what? Notice about what? No, that's all right. That is nothing to do with the matter.
Lord, if your
Well,
lordship
at
can
some
have, my
stage,
lord,
we
my
said we'll file a reply.
24th.
Formal notice has not been issued.
It's not that
no,
simple.
Court
let-
are
let's
It's not
upset at that
that
fact.
simple.
Let us read the order. Why
So
should
what
we-
is it that you're?
My friend will summarize this into a text message, but it's much more than that.
Meanwhile, you will read it.
My lord, can I have my
Yes,
copy,
yes.
my lord? It's
Yes,
not
yes.
marked, my lord. Lord, page 75 at 76.
By this court order dated.
Yes, my lord, by this court's order dated 8th November, upon being mentioned, this application was ordered to be listed on so and so. On so and so, two senior counsels have represented the second respondent, and this court passed the following order. Lord, please read the order, my lord.
That's right.
The prayer made in IA is for recalling of the judge. I'm sorry.
This is the first time the word apprehension is used here.
It was filed on 2nd of July. Second of July, so even if it's a review. On the day. First during vacation.
No, no.
July. Minister will see it's 5.5 months. 105 days. 30 days, what over? The budget will file a review in 30 days. We cannot file a review because it's a consent order dictated in around. Yes, submission will be.
Elections are in 26, no? We're in 25.
Next order at page 18 also.
That's not next, it's a previous order. Look at the chronology, backwards.
Check, right? It's going through 24 seconds.
It's all next.
So the court was aware that after.
Lord, would your lord?
He became a minister. The court was
Allow me to
annoyed.
read the order, my lord, it speaks.
The order that
It speaks for itself, my lord. Therefore, I could not resist the temptation of interrupting. It was factually incorrect.
You never
See, my
resist.
lord,
You
para
never
76, the present application at the foot, my lord, last. Application is based on apprehension. The apprehension is based on the fact that immediately after we enlarged the second respondent on bail by judgment dated 26 September 24, the second respondent has been appointed as a cabinet minister of the state. The apprehension is that considering the seriousness of the allegations against the second respondent in the predicate offences, the witnesses may not be in the frame of mind to depose against the second respondent, who is now holding the position of a cabinet minister. This is the only aspect on which prima facie we are inclined to consider the application. We make it clear that as there is no reason to interfere with the review taken on the merits in the order dated so and so, the adjudication of this application shall remain confined to the aforesaid aspect only. Today, we are not issuing notice as the learned senior counsel appearing for the second respondent seeks time to take instructions. Now, please see, my lord, even then, my lord, matter is kept on 13th March. Now, my lord, see, even on 13th March, the second respondent was, sorry, 13th December.
While he resigned and that.
No,
It didn't happen that quickly.
No,
That's the problem.
kindly, my lord, see
There's
that.
some inertia in power.
Yeah, that is.
No, my lord,
That inertia has to
something
be
which
overcome.
happened before the court, which court records, which is not being presented.
See how many ministers are being prosecuted, they don't resign, they're continuing to hold cabinet positions.
Yes, we have chief minister.
Yes, so we'll see that. Why don't they resign?
Yeah, that you can answer.
No,
if
you
you are
should
kind.
answer.
Anyway,
There are so many
I'll
of
not
them.
go into politics. I'm not in
Not
politics.
politics, this is a fact.
Even on 13 December 24, the second respondent was represented by a senior counsel. On 20th December 24, against the second respondent was represented by more than one senior counsel. On 12th February 25, the following order was passed. The learned senior counsel representing second respondent seeks time to take instructions from the second respondent. Please mark this. The learned solicitor general appearing for the first respondent submits that this court should specify on what aspect the learned senior counsel appearing for the second respondent is supposed to take instructions. I had this apprehension. As the learned senior counsel appearing for the second respondent is fully aware on what aspect is supposed to take instructions, it is not necessary to record it. To be listed on 4th March. On 12th February, the second respondent was represented by more than one senior counsel. Please mark this now. We are shocked to know that today the learned senior counsel appearing on behalf of the second respondent raises a contention that a formal notice has not been issued in this matter. Such hyper-technical contention should not have been raised. Notice is issued by the court for facilitating presence of a party before the court. The second respondent was all along represented by senior advocates. By this time, the second respondent could have obviously kept its reply or counter ready. Though such unfair stand is taken by the second respondent, we cannot be unfair to the second respondent. Hence, we grant time for 10 days to the second respondent to file a reply to the counter affidavit. Now, my lord, may I kindly come back, my lord, to my affidavit, my lord, page 6, para 9.
Mr. Solicitor, if he wants to withdraw the application.
My lord, kindly see, my lord, what I have said on affidavit. Page, my lord, thereafter, my lord.
That is only when we.
My lord, this is what, my lord, I apprehended. I said that you please record that he is seeking instruction whether he would resign or not. Court said, no, it has happened in open court. Why should it not be recorded? He knows what is to be done. Repeatedly, this was being done. And thereafter, my lord, please come to page 7 of my affidavit. I have again quoted the order of the court. My lord, page 7, para 3. The occasion for filing this application and for entertaining this application by the court arose as within 2 days after this court enlarged the second respondent on bail, he was sworn in as cabinet minister.
That's right.
Then your lordships have said, "My lord, now please see para 10. This is what I have said on affidavit.
Is he concerned about someone? Why is the solicitor concerned about whether he should become a minister or not? Why is the government of India?
Yes, because we are prosecuting.
So why are you concerned about whether?
No,
he
the
becomes a
government is concerned. You are pressurizing the witnesses.
The government is very concerned that he should
Yes,
not
yes,
become a
we are
minister. Why? Why? Are you interested in Tamil Nadu or what?
Anyway, my lord, I can't, my lord, enter into a political.
No, but
This is
the kind of.
wrong
this
forum
is
my
all
learned
politics.
friend is
What else
using.
is
my
it?
lord.
What
My
else
lord,
is
please
it?
come to
That
page
you are
8, para
arguing
10.
with such vehemence is all politics.
Page
What
8,
else?
para 10. Notwithstanding the
You have
fact
read
that
that
on.
para, you are pointing out that why the deliberately delay in application.
Yes, my lord, I have said that this is calculated delay in filing the application,
Followed, Mr.
waiting
Solicitor,
for,
but
my lord,
when the litigant does not wish to proceed with the application, so be it.
So let me respond to that, Balaji. This was on my application as well. My first application was mine. My concern today is simply this. We have seen the
Do
conduct
you
of this
have a
man.
counter relief on his application that you can resist the
No,
withdrawal?
no. So I'll give the reason because we have reached a stage where counters have been filed in this application as well.
Talking
At
of
which point,
counters, Mr.
no, I
Gupta,
understand.
you're
I
saying
understand.
that is there a counter claim on the application?
There's no counterclaim. My concern is this, because of what your lordships have voiced now, my friend will withdraw the application. He will then go away, wait, abide his time as he has done. He filed this application 100 days after the order came. Therefore, he waited quietly for one judge to leave and then filed the application.
Come on,
Yes.
Mr. Judge.
This will lead
I've
because
said on
of the
affidavit. I've
client.
said so on affidavit.
It's only on the conduct of the client.
One judge is still
The
there.
client
One judge is still
will
there.
come
Why do you
back
say
with an
that?
application at some
There's all
stage
going on
and
with
say that allow me to become a
Unfortunately,
minister again.
should not have been filed.
In all fairness, if the application is to be heard on merits,
Yes,
then Justice Mercy should also be part of the bench.
Yes, exactly.
that's correct.
Because his
That's correct.
lordship,
No, your lordships are right. It should be.
his lordship is
It
there.
should.
We were considering that aspect also, that
yes.
he should be request Honorable CJ
Correct.
to reconstitute the
Correct,
bench,
correct,
in
correct.
which Justice Mercy is also there.
Yes.
Maybe with us too, me and my
Correct,
brother
correct.
and Justice
Absolutely.
Mercy are there, then
Absolutely.
probably will be better enlightened about it.
Yes.
But we are right now not considering this proposal only for the reason that he is wanting to withdraw unconditionally.
Unconditionally, yes, my lord, not with a liberty or something.
But the problem is only this, that he will.
We don't
come with
even
an
mind if we
application
refer
saying,
to
"Allow me
Justice
become
Massey,
minister."
Bharat.
Understand, he-
We don't mind that, Justice Massey also. Why?
Become
Because
minister.
they made an application, he'll become a minister again, and then the judge said, whether he becomes or not is not our concern.
No, 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 no.
Yeah,
The
I was
orders
there.
reflect.
There's no
Orders
injunction, the
reflect
court said
everything.
no injunction.
Can,
Please, please,
Justice Massey will be there.
please do not.
I'll just clarify on the
No
first
one
day
told
when we argued that application,
Wait.
this judgment in Senthil Balaji where bail has been granted is an excellent judgment for bail. We have used it very often when we want bail in ED matters. So obviously the court didn't want to disturb what was a very good judgment on law where we were seeking the recall. That's why they say we're limiting it to this aspect that he suddenly become a minister 2 days later on the facts of this case.
Not
That's all it was.
Your
That's why.
lordships were not taken through the judgment of Justice Ramasubramanian,
They saw-
where the accused and the complainant jointly come before your lordships and there are strictures passed. How he is, my lord, dealing with the
Compromising.
witnesses,
Let's come-
compromising the witnesses.
Malad, if you're-
This was the background in the mind of.
There is a judgment of this court in Manoj Narula, para 64, Constitution Bench, and I just read 64. On a studied scrutiny of the ratio, we are of the convinced opinion that when there is no disqualification for a person against whom charges have been framed in respect of a heinous or serious offences, or offences relating to corruption to contest the election by interpretive process, it's difficult to read the prohibition of 75 and 164 to the power of the Prime Minister and the Chief Minister. That would come within the criteria of eligibility and would amount to prescribing an eligibility qualification and adding a disqualification which has not been stipulated by the Constitution.
That's not as.
But I understand. Well, I understand.
Arvind Kejriwal as a bail condition, your lordship
Allow me. All I'm saying is, Malaj, that this court did not say that there is a mandate that he cannot hold a position of power. Malaj,
No,
the
no.
elections
Mr.
are in.
Mr. Sibal, we don't want to go into the question of what was orally observed or not observed.
Yes, exactly.
We are going by the record.
That's
what is
correct.
recorded there. There is no ambiguity in the order. There is nothing which requires any further explanation from our side.
Correct,
The language of the order is very clear.
correct.
So probably your application to our mind is completely misconceived. And if you want to withdraw, we will simply dismiss or withdraw on the.
That's fine,
application.
Malaj. I just said that, the point is, Malaj, we did not want this to be
Lunch-
interpreted as a mandate, that's all.
He's
They are
in the
entitled to
position,
move an
but that is our
application.
case.
Malaj, if he goes the position of power, they are entitled to move an application and say that, look, he's not entitled.
But
he has a matter of law.
contemporaneous
We'll
reports,
argue that, we'll argue that.
God puts to Mr. So-and-so, choose ministership or freedom.
What is your concern about it? You're the
I am
government of
concerned
India.
because my
You are the
witnesses, my
government
lord,
of
I am the
India.
prosecuting agency.
If the witnesses are being influenced, you get the bail cancelled. That is the law.
That was argued before the bench.
No, there was no such
This
argument.
was argued.
No, and it was not cancelled.
And the
for
court
that
said,
reason.
no,
No, it is
you
only
choose
on the
between the
question.
two,
Anyway,
freedom
Maharaj, there's no
or
point of this
ministership.
and that. Let the government of India, Maharaj, be concerned about it. We will do what in accordance with law, what we are.
Lunch senior counsel for the petitioner seeks and is permitted to withdraw the application. Dismiss or withdraw.
Unconditionally, your lordship.
No need to say
Unconditionally.
unconditionally. No, not to say.
That's what he said.
He said,
I am
he
withdrawing
said
the
unconditionally.
application.
Unconditional.
No, I am withdrawing
this
the
is not-
application.
We are saying dismiss or withdrawn, that's
all. Deeply
He
obliged.
said unconditionally.
No, why?
Lord, I earlier also said that please record what has happened.
But
The court trusted
I
him.
object that. I object to that.
No.
Are you are objecting
Somebody
to
has
what you
filed-
said?
Mr. Solicitor, someone has filed an application. He doesn't want to press the application. wants to
Eventually,
press.
when your lordship's order comes, they won't know that 45 minutes of argument happened with this one line.
That's
Yes.
the court.
This is
That nothing happened. We only withdrew because we wanted to file a fresh application. Or we wanted
There's no
them
fresh, there's no
to
fresh
file a fresh
application.
application.
There's no fresh application to be filed.
Your lordship may
Yeah.
say after long
So
arguments.
like after,
Yes.
after arguing the application for a considerable length, lunch senior counsel for the petitioner seeks and is permitted to withdraw the application.
Fair enough, Manoj. Yes.
Dismiss as withdrawn.
Yes. Most of.
Great.
Correct.
What's the
Now,
other
there are two other matters.
31 and 37.
See, one solution can be
Yes, I'm on.
where maybe that today we will hear it on appropriate day, but all of you can think of why not this trial be transferred to Delhi?
Transfer to Delhi, we have no problem. I think that's.
I have no issue. I have no problem.
He may not have any issue, but as a state, I will have issue.
Mr. Tiwari, what will happen?
Lord, in the
Lord, I-
predicate
can I-
offense,
can I-
wait a minute,
Well, none of the accused are parties.
Right to speak in predicate offense.
In a predicate offense, I am ED. I base my investigation on predicate offense. Nothing is done by the local police.
This is unfair, my lord. How, if I have not
It
done
is unfair,
anything,
That's what I'm saying.
your statement is unfair.
No, we are not saying investigation to be transferred. We are talking of.
Lord, now it is
yes,
at
yes.
trial
Trial.
stage. It is at the
Accused
trial
are not
stage.
parties, Manoj.
My lord, it will be
Accused are not
Lord,
parties.
The 2000.
But whatever, they are not parties, Manoj.
possible.
We are not
My lord,
passing an order today.
My lord, it will not be possible to conclude the trial if it is transferred. All the witnesses are based in Tamil Nadu.
They can appear
Everything.
online, they can depose
My
online.
lord,
Well, nowadays-
may
nowadays.
Before, my lord may even make this suggestion.
State
Lord,
oppose.
yes,
The accused
yeah,
can
it is because you are, my lord is, the moment it is transferred, it is look like as if there is no trust in this system. My lord, and trial is about the courts, my lord.
Mr. Tiwari, we are not even mentioning in the order today.
Yes.
We are only saying that why not every day you will invite allegations. The state is doing, this state is misusing, this state is doing. Only to keep yourself also in peace and away from these allegations which are bound to come every day, some application will come.
Lord.
If the trial is transferred to any neutral place,
Yes.
the witnesses can depose online. We can directly, wherever it is transferred to a dedicated court to take up the matter on day-to-day basis. Why we are saying? Ultimately, suppose the allegations are false,
Yeah.
and this gentleman, who is a public figure, who is after all politician, suppose he has been falsely implicated, assuming, he will be exonerated. He will resume his public life.
For him also.
My lord,
Well, can I
as a
just-
state, I have no difficulty as far as expedition in trial and all other things. My concern would be the moment my lords transfer the trial, it would appear as if we are not as a state performing our duty.
We will record everything. We will record
Well,
everything.
see the past orders passed. There have been orders passed earlier. Your Lordship is being told without.
All
Lordship,
these
This
applications.
very
are being-
application.
Yeah, all orders are read.
No, not all orders are not read.
Mr. Mehta, I don't have to be here to know that you are arguing Mr. Sibbal's case. This is my case now, 31 and 37. I hope that's not your best argument. You have not read a single order for clubbing, for segregation, for
trans-
transfer.
Transfer.
All
the-
orders are passed by the bench of then, once Justice Oak Mullis, once another bench, and those orders are not told to your lordships. Today, really, I can place it.
Since I'm the petitioner, I may be permitted, since Dr. Singhvi also doesn't want to argue as a respondent surely. I'm the petitioner.
I am saying
It's
don't
my
pass
petition.
any order which is covered already by lordship's order.
Dr. Singhvi, today we are only giving a suggestion. We are not, we are only
Well,
saying.
it actually, your lordship knows, your lordship's bona fide suggestion, how it is projected is about everywhere, not only media ones. Lack of faith.
Media, we are not concerned.
Mr. Mehta,
No, we are not concerned with media.
I am concerned. I am a state because you will say it's a biased state. It
No, no,
doesn't do
that part
investigation
you can
properly,
leave to
votes
us.
no confidence in the state. Of course, we are concerned.
Dr.
This is how the.
Singhvi, Dr. Singhvi, that part you can take from us.
I'm gonna say,
We
no
can
confidence
assure
in
and
the
we can
entire
reassure.
judiciary.
We can assure and reassure that there is no any
Manas,
such
your
ground.
lordship's intention is not that, I understand. But Manas, the impression about the whole judiciary in the state, let me do one thing. Your lordship has said something today. I can place a compilation of orders and read them to your lordship, then decide. Don't take it like that, Manas.
No, we are not deciding
Ah,
today.
yes.
We are only suggesting, why don't you all of, we are
This is
talking of
a
a.
trodden path. He comes up with a new IA every time.
Every time.
After the 3 orders,
I
he's
haven't come with
three
any
new
idea. I have a
What-
SLP here. I don't know what my friend is
Solicitor
talking
was
about.
Requesting for Mr. Sibbal's client, Milord, I request for these applicants.
Manoj, can I,
It's a camouflage of the solicitor
Seven
not supposed to
applications
be Gopal.
rejected and then they come with
There should be a-
8th application.
There-
And some
Sense of the solicitor
PIL,
not
the other
supporting Mr.
PIL
Gopal.
petition, Lord.
Please appreciate where in the.
I hear your lordship. I hear your lordship.
The particular state where the trials are there, witnesses are there, the atmosphere will always remain charged. Unfortunately for you, state, the opposition people, they will continue to accuse you for any, if the delay happens on part of the court, you
But
will.
whereas
be blamed.
on a apprehension of a speculative basis, your lordship on the other hand has passed orders commending the state's conduct. The orders are passed commending the state's
not in this
conduct.
case.
In this case, I'll read the orders.
We will comment,
Never-
stand here also, that's why we are saying that please have instruction, we want to pass a consent
Whereas
order.
your
not a-
lordship may,
Anyway,
defer it, I
take it up
will
on
place
another
on
day then.
record, whatever is the conditionality, I'll place on record, but don't.
Can I just, Manoj, since it's my petition,
No,
no,
now,
no formal notice has gone. Your lordships will remember in that other matter also, they said, no notice has been issued notice. So please formally issue notice. I don't want to be told later that
Not be required because earlier SLP.
Item
dismissed
31.
On the very same.
item 31,
Same. review,
formal
SLP
notice your lordships may
Now
not have
another person
given.
comes in another name and say
Now-
that he was not even made application
This
before the
this
High Court.
SLP is on the same point, that's why lordship didn't issue notice, just keep it as it is, just call it after.
State is there to accept notice.
Note and
So,
Polite, we may not necessarily land up to pass an order without hearing that, only to, you are here, only technically there is nothing new in it.
no, the second thing, second,
Just a minute,
yes,
this is
Mr. Mehta should
SLP
argue
criminal
that side.
39380.
Is there no
yes,
pretense of
Manoj,
not
yes,
arguing that side?
yes. It is that,
Issue notice,
yes.
then, who is assisting Mr. Tiwari?
We'll file a discovery.
So and so AR accept notice on behalf of principal number, principal number 1 and 2.
Well, it's including my preliminary objection to maintainability. of the
Principal number
SLP.
1, principal number 1,
Including my,
all right,
Prasad is on.
for
camera.
Ganeshan.
Yes.
well, it's including my
That's-
preliminary objection to the maintainability of the SLP.
petition at the behest of this.
The reply, if any, or any, you want to file a status report on it.
No, also a reply on the maintainability of this SLP, including that objection only, I'm saying, keep it open.
The reply, if any, we filed within 2 weeks, post the matter of this one and the
Very
other
good.
matter connected.
I just,
We are not
Including
mentioning-
maintainability of
Correct,
SLP,
correct.
that word should come, including maintainability of SLP.
that he can anyway file.
Doesn't need on the maintainability of the petition,
Obliged.
may file within 2 weeks. We are not mentioning anything in the order, please.
We will find.
We will.
May I-
Hope it.
On that suggestion that fell from the bench, I just want to say one thing. Two things, in fact. The first is, below, the accused are not here, except for that one Ganeshan. So I don't want them to say, look, this was behind our backs. You have decided that the trial can, or the witnesses can be examined. That's something your lordship may bear in mind. The second, when the chief minister of Tamil Nadu had the same case against her, your lordships had transferred it just a few hundred kilometers into Karnataka.
Karnataka.
It's something worth bearing in mind, because as against Delhi for witnesses, maybe Karnataka, Pondicherry, something else.
Come back,
where
I'm
that-
objecting to
come
many
back.
things. Let him not just say, I will just come back on that.
We'll come back.
Bolo, bolo.
We would not want